Good afternoon, counsel.
Good afternoon, Your Honors. Could I request 3 minutes for rebuttal, please?
You may have 3 minutes.
The representation of Mr. Brown was completely unethical. A lawyer cannot accept payment.
Let's assume that's correct. Does that answer the question before us?
It should in part. It's not completely binding, but the ethical rules do in fact weigh in. And when this court is deciding whether a certain type of representation should be unwaivable, certainly if the ethical rules say that it cannot occur, it would seem like it would make sense.
Wouldn't that mean that any improper conflict then would be an unwaivable one?
No.
Because any improper conflict is against the ethical rules. So following your argument then, it seems to me that we'd have to say that you could never waive a conflict.
Well, I think there's a difference here, which is when we're talking about a broad category, when there's a current client who is paying for a concurrent client's representation, that is a broad category that should simply not be waivable. But it's the conflict is, of course.
Let's say you have a company that's under investigation, and you have a CEO. Company pays the for the CEO's lawyer. That's okay, right?
I presume so.
Right. So now let's say the company is being investigated for some other environmental case, and that same lawyer is representing the CEO in the criminal securities fraud case, let's say, and the company's paying for that lawyer to represent him. That's not waivable. That CEO can't come in and say, I want this lawyer, actually. I have a right to counsel of my choice. I know they're paying. I know he's representing them on an unrelated environmental matter, and I want this lawyer. No way. Judge has to disqualify the lawyer. It's unwaivable.
I mean, it's certainly unethical. So
but we're asking about unwaivable. So that's unwaivable.
It would seem odd that the court would say, you know what, you could continue in this completely unethical representation.
But isn't that what they do in a conflicts waiver all the time? I mean, a conflicts waiver is a divided loyalty waiver. Now, that's unethical. You should represent one client. But there is a right to have the lawyer of your choice that butts up against this, right? And our cases speak about that balancing. So you want to put, it seems, the hand here to say in all cases the judge looks at that client and says, I don't care, you're a sophisticated person, you know what you want, you were putting a full waiver of all of this, but I know better than you. And this is a violation of the DR rules, and you can't have that lawyer.
And the ethical rules do, in fact, permit waivers. One wouldn't be permitted here. But let's turn to the facts of this case as to what makes this case so extraordinary. I mean, it wasn't just a concurrent representation with one of the individuals paying for both of them. The individual we're talking about here, Salam, is deeply implicated in this murder. There is significant evidence pointing.
But you can represent co-defendants. I mean, how much more implicated can you be? You can waive. You can have joint representation. I mean, your co-defendant's pretty implicated in the scheme.
Well, it's not just the implication. It's the fact that their interests, are diametrically opposed here. Salam needs to keep himself out of this murder case. He wants to be scot-free and get away with this.
What evidence has the defendant come forward with of Salam's involvement in the shooting?
There is a huge amount of evidence. It starts with the motive. He has more motive.
Is any of it, is there any admissible evidence?
His motive is, of course, admissible and was admitted.
Yes, but who's going to present the evidence of his motive?
It came in at the trial in this case. His motive was he was robbed. A gang leader was robbed and disrespected in his territory of $5,000 in cash and his $15,000 Rolex, excuse me.
Dated yourself with that.
Getting too old. And then returns to the scene with his armed posse.
All of that came in. All of that came in.
Yes.
So what's the conflict to keep out? What wasn't presented?
Oh, I don't think that's the appropriate analysis.
But if it's a potential conflict, it kind of is the appropriate analysis, right? Because then did it affect the conduct of the defense?
Sure, it's not merely limited to what didn't come
I mean,
out.
putting
but-
aside the waiver here.
But we could talk about what counsel should have done.
What was the role of counsel at the Gomberg inquiry?
The role of, I'm sorry, are you talking about the independent counsel who was this?
No, trial counsel.
Trial counsel needed to inform the court and independent counsel of the scope of the conflict. And he utterly.
So wouldn't we need to, procedurally, wouldn't there need to be a hearing before any determination could be made on waivability or unwaivability? In other words, if we ruled as a matter of law under these circumstances that this is unwaivable, wouldn't that be a premature adjudication, given the fact that the court did not really have all the facts before when it made that determination?
Perhaps, if there are actually facts in dispute.
So it would seem that if the more prudent course, if we were going to do anything with it, would be to send it back for a hearing for the court to be able to put Mr. Chabron, is that how you say his name?
Chadbrow.
Chabrow, I'm sorry. Chabrow on the stand.
That would not be inappropriate if there's in fact disputes at issue. In terms of the Gomberg inquiry itself, though, this court in Cortez put the obligation not on counsel, but on the court to make that full record.
Well, what more
And that-
could the court have done, given what the court was told at the time of the Gomberg inquiry?
Well, the court knew a lot of information about Salam's involvement at that point. It wasn't
But did
merely
the
that
court-
Salam.
Did the court know that Salam had paid for the attorney's fees?
No, both Mr. Chadbrow and the prosecutor, which the prosecution knew, both of them decided to keep that from the court.
Well, did Mr. Chabreau, did you ask Mr. Chabreau, when you were making the 440 motion, why he didn't say anything?
According to Mr. Chadbrow, he couldn't see there being any conflict or any problem with this whatsoever, so he did not inform his client of any of it and didn't inform Eric Sears, the conflict
What
lawyer,
are
of
the
any
two
of it.
lawyers' roles when they know that a defendant, during the course of an inquiry made by the court, is misleading the court? When the court asks, are you or your family paying for this lawyer? And the defendant, this is my recollection, correct me if I'm wrong, and the defendant responded yes, indicating either he or his family were paying. Are you suggesting that the lawyer who has different information has no obligation as an officer of the court to correct that record?
Two answers. One, of course, the attorney has an obligation to. The second point is that wasn't actually the question that was asked. The question that was asked was whether you or your family has hired this individual. And in fact,
What did he respond?
Mr. Brown did cause Mr. Chadbrow to be hired. It was through his family. And yes, I agree it could have been misleading. Both the prosecutor and Mr. Chadbrow probably should have brought that to the attention of the court. I don't dispute that, but that shouldn't be laid on Mr. Brown.
I wasn't suggesting that.
One of my concerns here, though, is that if you have this unwaivable conflict rule that you're advocating, doesn't that give the defendant an opportunity to go forward with that conflicted lawyer and then come back later on and say, well, I lost the trial and turns out so-and-so was paying for it. And I mean, it's sort of allowing him to be the architect of his own second bite at the apple, if you will.
One would think, going back to the Chief Judge's point, that the attorney has an obligation to complete candor to the tribunal. Plus, I've yet to see this mythical defendant who embraces being convicted of murder in the slim hopes that his appeal is somehow going to be victorious many years
Well, but it is
down the
possible.
road.
It's possible, right, that a defendant would be willing to risk a conviction of murder to protect someone else with whom that defendant is close or aligned or loyal or whatever.
I think this case speaks to that.
Okay, so if let's say this had played out differently. Let's say this was all above board, And this defendant said, no, I didn't, I chose this lawyer, but Salam is paying for the lawyer. And all of a sudden, the lights go off, and he says, okay, wait a minute. This is a serious conflict, and explains it to him in every way possible. And he says, it's okay. It's all right. This is what I want. I want this lawyer to represent me. Can't do it? Can't do it?
I don't believe this conflict should be permitted by the court at all, because it permits someone like Salam to pull the puppet strings. He's paying for my client's defense. He's paying for the co-defendant's defense.
What if the defendant knows that Salam didn't do it? The defendant knows, nobody else knows that he pulled that trigger. What if he knows that?
This is the defense in the case, that he needs to explain the two pieces of evidence against him, why one of Salam's underlings is fingering him, and why he confessed. The defense in this case is simple. It's because Salam did it. No reasonable, rational defendant would ever accept that. And for the court to accept that waiver, knowing everything that the court would know here, would be permitting a defendant to, in essence, commit suicide and to protect the guilty party.
Counsel,
or
can I just
potentially guilty
clarify?
party.
I'm just trying to understand the basis for your analysis. Are you arguing at all that under the state constitution there's some greater protection, or the cases under the federal constitution coextensive? They apply here?
I think it's coextensive in this case. Wood v. Georgia talks very much about this exact type of conflict where we have, the language
So you're
from
not
the
asking
Supreme
us
Court.
to decide that the state constitution should, an argument under the state constitution requires some different analysis?
I would happily embrace that for the result, but I'm not sure that's at all necessary or even necessarily appropriate here. And just to be clear, even if this is a waivable conflict, it's clearly an actual conflict that was not waived, and it's equally clearly that I'd also went under the third prong, that it clearly impacted the representation here, and it was not waived.
Chief, may I ask one question?
Yes, you may.
I'm sorry. I don't see a challenge to, let's say this conflict issue wasn't in the case, the third-party payer. There was a conflict, dual representation conflict. You haven't challenged, as I understand it, that waiver proceeding with respect to that conflict.
Oh, I absolutely do. That the entire waiver proceeding consisted of the court and independent counsel just saying to Mr. Brown that Salam, we know he was there, so we don't think he's going to be called as a witness. The prosecutor isn't calling him. You're not calling him. Maybe he'll be called. He'll take the fifth if he's called. In the unlikely event, your counsel will have a hard time cross-examining him. That's not at all what the dual conflict issue is in this case.
Your argument, and also below, and I'm just asking, I don't know, was that proceeding was insufficient to waive the dual representation conflict.
Absolutely. The court never told the defendant he had a right to conflict-free representation. The court never instructed him on the dangers, and the actual conflict was never explained to Mr. Brown or independent counsel.
If the court had done that, would that have been sufficient to also waive the third-party conflict?
The third-party pay
Yeah, I'm sorry.
conflict? No, absolutely not. That
What's
represents.
the difference there? What's the delta? What additional conflict waiver would be necessary? What dual loyalty problem does that raise that wouldn't have been waived in what you describe as a full conflict on the dual representation issue?
Because we would have a tremendous concern that it's not merely split loyalties, but that counsel is operating under this bias of payment from the paying client, and that it's much worse than just dual loyalties. His first loyalty is now to Salam.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Sylvia Wertheimer for the people. It's critical to the analysis here that, as Judge Garcia said, the defendant also has a constitutional right to counsel of his choice. Here, he exercised that right, knowing that Salam was present.
Counsel, there's, though, a recognition that some conflicts are just not waivable. Granted, I know that the two of you are debating what kinds of conflicts may fit in that particular category, and I think even the defendant recognizes a narrow category. But why doesn't this fit? When it seems to me you've got three things going on. You've got the representation of a suspect. You've got the suspect paying for the representation of the defendant. And you've also got that it's not just a suspect, it's that you're going to point the finger at that suspect as being the person who's the shooter, right? So it means that the defendant is not guilty of that crime, but that Salam is. Doesn't that make it slightly different from just pointing at a witness or a suspect who may be implicated in some part of the crime, but doesn't necessarily mean that the defendant would be found not guilty of that particular charge? Isn't that slightly different?
Well, first of all, there was no credible, admissible evidence here that Salam was the shooter or played any role.
Well, let me just go with this hypothetical. What if there was? The three things that I've pointed out, if that's what the evidence showed, would you say that in that kind of case, that might be one of those small number of cases that fits within, again, that narrow category of non-waivable conflicts?
It might. I mean, it should be a very narrow category, but the problem is that here there's absolutely no evidence that would support that Salam was the shooter. We also have a situation where defendant...
Well, do you need that kind of proof? Isn't this a question of just a defense that could be mounted? And isn't there enough here to mount that defense? Whether or not it would be successful is another story. Obviously, that doesn't even get you ineffective assistance of counsel.
But the defendant here knew. He was there.
Mm-hmm.
So if he knew, as the people submit and as the jury found, that he himself fired the shots, it certainly makes perfect sense for him and would be totally rational for him to say, well, I'm not worried about making a defense that would point the finger at Salam. I'm not going to falsely implicate my friend. And I don't think this court would want to endorse a notion that lawyers are required to somehow present defenses that there's no reason to believe is true, and that even the defendant who was present won't say is true and has never said is true.
Isn't it hard to say that this didn't in fact operate on the defense when the people introduced testimony from Detective Walla saying he had never heard that anyone other than the defendant had fired the gun, and then defense counsel attempts to cross-examine Walla based on Walla's own notebook that says that Ant Warrior told him that Ock shot him, and the court then has to resolve this problem and says, I'm going to strike everything. Didn't it operate on the defense?
The judge struck it because there was no admissible evidence, not because it wasn't that Detective Walla had spoken to Ant Warrior. Detective Walla explained, and the prosecutor explained, that the notation indicated that somebody else told the detective.
He struck Detective Walla's testimony as well, right?
But it was hearsay, on the grounds that it was hearsay. It was rumor. Detective Walla, he had not spoken to Ant Warrior. Detective Walla had spoken to somebody else who said that Ant Warrior. Now, here, in the 44010 affidavit, now you have counsel's accusing the trial counsel of not having properly investigated because he was under the strings of Salam. But now, 3 years after the conviction, with new counsel, we have not one shred of additional evidence, nothing from Ant Warrior, nothing from Mel, nothing to substantiate what was totally hearsay and rumor. And that should not be a basis for finding an unwaivable conflict or that anything operated on the defense.
Wasn't that the purpose of asking for the 440?
Excuse me?
Wasn't that the purpose of asking for the 440, to try and get evidence of that nature?
No, I don't believe so. I think in order, first of all, to get the 440, it was incumbent upon him to come forward 3 years later with something. Also,
So couldn't he have come forward in his own affidavit with saying somebody else, this guy is the one that did it?
Right, I mean,
Why? I was there, I saw it. He, you know,
it smacks of such gamesmanship to say that I didn't know my best defense would have been when he's not there and he won't say that that's actually what happened. And in terms of the operation on the conflict, I mean, this was a strong evidence of guilt, a case where there was strong evidence of guilt that left defense counsel with few, if any, good choices. But a disinterested defense counsel certainly could have decided that the best thing to do would be the defense that he mounted. He tried to blame Quadrato, the identifying witness, and say that it was him. He tried to suggest that the people's proof generally was not credible and should not be believed. The pointing the finger at Salam would not have undermined Quadrato's identification testimony. There's absolutely, the defendant distorts the evidence, the record a lot. There was absolutely no evidence that Quadrato had any part in any gang that involved, and therefore that it wouldn't have effectively undermined his identification testimony. Also, the notion that it operated...
Counsel, I'm sorry, is there an allegation that the prosecutor knew that there was a third-party payment here?
I believe I just heard counsel say that, and I would submit there's nothing in the record to indicate...
Is it in the 440 anywhere?
No. In fact, in the 44010, the prosecutor disputes and questions whether that's even true. The one person, of course, who did know that Salam was paying was the defendant, who misled...
Well, see, that brings me back to the hearing question. Wouldn't this mystery be solved about whether or not there was a payment and by just bringing the attorney in for the 440 and have him answer these questions?
Well, we're assuming for the sake, no, because we're assuming for the sake of the 44010 that it is true that he paid, but we're saying even if that is the case, because of the evidence
in the reason I ask is because the theory of an unwaivable conduct seems to rely in the proof of these benefactor payments. It's kind of the underlying legal philosophies behind the case. Schwartz and the other cases that came on the Second Circuit have to do with benefactor payments. And I'm thinking, how can this issue even be addressed unless you have that attorney come in and testify, and the court opens it up for a hearing and then see what happens?
Well, but in this case, we accepted because Schwartz was a very unusual case. The Second Circuit itself has stated that Schwartz was a case where there's a $10 million multi-year retainer agreement. Nothing like that happens here. We're saying that even if it's true that Salam paid for the lawyer, it could not have operated on the conflict or resulted in an unwaivable conflict. It resulted only in a potential conflict that didn't operate because there was no evidence, no reason to believe that Salam participated or was involved in the shooting. He did not, there's no evidence of any conduct. The defendant referred to motive. Motive isn't conduct, it's just speculation. There's not one thing here to suggest that Salam is the person who committed.
There's motive and there's the fact that he went back, right? He went back, and they weren't just going back to kind of hang around, right?
Yeah, he went back, but that doesn't mean
So he's
that
at the scene at the time.
Yes, he was at, and that's classic presence. Mere presence does
You got
not...
the 9/11 call that mentions
9/11
him by name or nickname, whatever.
says Ak and them.
Right.
So, I mean, and that's because maybe people know Ak.
Well,
but,
the question is that sufficient? Forget about an unwaivable conduct. Let's just talk about opening up a hearing. It's not the same thing. I think, forget about the end result for a question. The question is whether or not the court had sufficient evidence to make a determination that it wouldn't open a hearing up. And this seems to me to be at least sufficient to require the court to ask a few questions, to bring Chabran in and ask some questions. How do we not do that? How could you not want that? It's just a simple search for truth. And the court did not have all the information in front of it when it made its initial determination.
well, but because the court had presided over the trial.
So maybe another judge needs to decide it, but nonetheless, a court. I'm not criticizing this judge at all, but because I don't think that this judge had all the right information. But a court, a tribunal, should in any circumstance have this information in front of you, at least the opportunity to ask that question.
To ask, I'm sorry, I don't understand what question.
You don't understand what question?
What question they would ask, because, I mean, the question would be, were you in any way affected in your representation here by the fact that you represented Salam? And the answer would be, is clearly from the record, no.
Questions like, did your lawyer talk to you about possible plea negotiations? Did your lawyer talk to you about possibly cooperating with the prosecutor? Things of that nature for the judge to, 440 judge to determine.
Well, I mean, he says that there were no such no such discussions.
But of course, he said isn't the same as having a judge ask those questions in the context of a 440 hearing.
No, I'm talking about the defendant said that he did that there was no discussion like that. And again, it all comes down to the fact that there's no reason to believe that Salam was the shooter or did anything. He wasn't involved in an attempted robbery. This was the jury found this was the act of the person who fired the gun. It was the only person who was responsible for the shooting. There is absolutely no evidence that that was Salam. And therefore, you can't, there's nothing further to explore to suggest that it would have operated on the defense by failing to raise.
See, everybody's different, and there's an element of discretion involved here, in fairness to the court and to all of you. But if I had been sitting there, I'd think to myself, once information had been withheld from me that I didn't have when I made my initial determination, I'd want to ask a question about it and see where it led. You're assuming what the answers are going to be, and you may be correct, in fairness to you, but logically, until those questions are asked by the court and the court makes a determination and has it all in front of us, it seems to be an inherent failure of the process, then, that the sanctity of the process is undermined by the failure to ask those questions.
Well, I respectfully, would disagree, because I think that the record here as to everything that happened shows that there just was no basis.
You understand, I'm not arguing for an unwaivable conflict.
But there was no
I'm
basis.
just arguing that some questions should be asked here.
But there was no basis for this defense, for a defense that would have fingered Salam. It wouldn't have been a better defense. There's also no evidence in this record that it.
Would it be worth a 440 court exploring what exactly conflict counsel knew and what he advised?
The independent counsel?
The conflict counsel. Yes.
I believe that the record is sufficient as it is. Critically, the records show, I think it's very.
Conflict counsel, no. Isn't there an affirmation in there that conflict counsel was not aware that someone else, that Ahmed Salam was paying? Isn't that a key factor for conflict counsel?
He wasn't aware. But the payment, again, only makes a difference if there's evidence and reason to think that Salam was involved in the criminal conduct. Again, it might be an ethical violation.
There's a witness who said, I saw a man go into a car with a gun and leave right after the shooting, and that's clearly not the defendant.
That witness, the defense counsel here asked to speak with that witness. That witness ultimately said, what the prosecutor said is that witness said that the person she saw had braids, which matched defendant's appearance, and that the person in the lineup who looked most, she just wasn't sure to make an absolute identification, but the person she saw who looked most like that person she saw with the gun was the defendant. And it was after being told that the defense counsel decided, I'm not going to talk to her and I'm not going to call her, because that witness also would have supported the conclusion that it was defendant, it was not Salam. So that's, again, it was a total misrepresentation. That witness would not in any way have supported the notion that it was Salam. That witness, she said the person had braids. We understand that, that all of these rights are very important. But again, I think as just Rosia said, there's also a concern about gamesmanship here. And we submit that this case should be resolved in a way that doesn't promote gamesmanship. and doesn't rest on distortions and speculation, and we ask that the conviction be affirmed.
Thank you, Ms. Wertheimer. Mr. Clem?
In response to Judge Garcia's question about whether the prosecutor knew, I'd direct you to pages 113 and 114 of the appendix. That details the Rikers call and Bergen County calls, which were turned over by the prosecutor to the defense, where it's unmistakably clear that Salam is the one paying for both their defenses.
Do we know when that was, when the prosecutor received those calls?
We don't know whether the receipt, we don't know is
We
the
don't know
short
whether it
answer.
was before or after the
It was
Gomberg.
before trial, but I'll point out that at trial, when the judge at trial got concerned all of a sudden that, oh my God, Salam is all over these materials, how could you be representing him at the same time? It was the prosecutor who assured the court at the time, don't worry about it. We did a full inquiry back then. So the prosecutor certainly knew at that time.
Counsel, you cited Wood v. Georgia before about the Supreme Court's view of third-party payments, but Wood v. Georgia, the Supreme Court sent that case back to determine whether or not there was a conflict, and if so, whether it was waived. So I read Wood v. Georgia as saying this isn't an unwaivable conflict.
I didn't mean to suggest that they were holding it was an unwaivable conflict. They were pointing out the inherent dangers in this type of arrangement. I do want to talk about the evidence here because my adversary keeps saying there's absolutely no evidence. We went through the motive, we went through the opportunity, we went through that he was present, went back there with the gun. The 911 call we talked about, we're in the background. I think it just says Ak, maybe it says Ak and them, but it certainly refers to Salam, not Mr. Brown. We didn't talk about how it was Salam's car that got trashed, with everybody explaining why they trashed the car. They trashed the car because the shooter came from the car. They trashed Salam's car, and that was admitted at trial through Detective Walla.
But all of what you're describing, it seems to me that it would be pretty risky to bring in all that evidence, because it seems that it equally implicates the defendant.
It all came in, so it wasn't a matter of risky or not. It was how you then use that evidence at trial. But I want to talk about Ant Warrior, because I think, I'm sorry.
No, go ahead.
Ant Warrior, there's a Brady disclosure. You're representing a 20-year-old kid in a murder case. You get a Brady disclosure which says Salam is going around saying, or Ant Warrior, who was present at the shooting, is saying Salam fired the shot. What would you do? Any counsel is going to investigate that up the wazoo to get a hold of Ant Warrior and get him as a witness. And what do we know happens here? Well, Chad Brow puts in a call and leaves a message for Ant Warrior, but then he learns, I wonder where he learns, that Ant Warrior is adamantly opposed to cooperating. So he drops it. That is classic conflicted counsel. Had Salam not been paying for his fee, any other attorney in this murder case would be investigating that and would be seeing what they could get as admissible evidence. If my adversary is correct, which I don't believe she is, that there's overwhelming evidence in a 20-year-old facing murder charges, what would you do as unconflicted counsel?
If much of the evidence you already pointed to was brought in at trial, is this really a complaint by the defendant of you just didn't do enough, as opposed to you didn't really present my defense?
No, I mean, it's much more than that. And again, this is a conflict issue. I mean, it's not that we have to prove innocence here or something. This is having an attorney whose loyalty is divided and here hopelessly conflicted. What I was getting at before is, if it truly was overwhelming evidence and you had a 20-year-old facing murder charges, wouldn't you talk about a plea discussion? Maybe the prosecutor is interested in the kingpin here. Maybe the prosecutor is interested in going after Salam, the one who's...
Bring another 440 on ineffective assistance of counsel.
Another one may lie on that, but certainly one lies on the conflict claim. We'd ask that Your Honor's reverse on that matter. We're happy to have the hearing, because I don't think any of these facts are actually really disputed. But to the extent that the court feels that a more broader record is appropriate, we'd be happy to make that. Thank you.
Thank you.